Hi, my name is Claire P. Bungkasan from Section B, TTH 5:30 to 7 p.m. and I'm making this oral video presentation that serves as my final examination in the subject CLJ400 evidence. So I'm going to answer the questions provided by my instructor. Here we go. The first question, define evidence and explain its scope. Evidence is the means sanctioned by these rules of ascertaining in judicial proceedings the truth respecting a matter of fact. Scope, the rules of evidence shall be the same in all courts and in all trials and hearings, except as otherwise provided by law or these rules. The next question, what are the three kinds of evidence? Briefly explain each. The first one is object as evidence. Objects as evidence are those addressed to the sense of the court. When an object is relevant to the fact in issue, it may be exhibited to, examined, or viewed by the court. Next one is documentary evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, or sounds. The next one is testimony confined to personal knowledge. Witness can testify only to those facts which he or she knows of his or her personal knowledge. And the next question, distinguish corroborative evidence from cumulative evidence. Corroborative evidence is additional evidence of a different kind and character tending to prove the same point. It is a piece of evidence that may be derived from various sources but proves a common point. Meanwhile, cumulative evidence is additional evidence of the same kind and character tending to prove the same point. Next question, what is prima facie evidence? Prima facie evidence is evidence which, if unexplained or uncontradicted, it is sufficient to sustain a judgment in favor of the issue it supports. What is a dying declaration? According to Section 37, dying declaration, the declaration of the dying person made under the consciousness of an impending death may be received in any case wherein his death is the subject of inquiry as evidence of the cause and surrounding circumstances of such death. Next question, what about statements uttered as a part of res gestae? As what indicated in Section 44, part of the res gestae, statements made by the person while a startling occurrence is taking place or immediately prior or subsequent thereto, under the stress of excitement caused by the occurrence with respect of the circumstances thereof may be given in evidence as part of the res gestae. What is the order of examination of individual witness? Briefly define each. In Section 4, order in examination of any individual witness. The order in which an individual witness may be examined is as follows. A. Direct examination by the proponent. B. Cross-examination by the opponent. C. Redirect examination by the proponent. And D. Recross examination by the opponent. In Section 5, direct examination. Direct examination is the examination in chief of a witness by the party presenting him or her on the facts relevant to the issue. Section 6, cross-examination, its purpose and extent. Upon the termination of the direct examination, the witness may be cross-examined by the adverse party and on any relevant matter with sufficient fullness and freedom to test his or her accuracy and truthfulness and freedom from interest or bias or the reverse of the illicit all important facts bearing upon the issue. Section 7, redirect examination, its purpose and extent. After the cross-examination of the witness has been concluded, he or she may be re-examined by the party calling him or her to explain or supplement his or her answers given during the cross-examination. On the redirect examination, questions on matters not dealt with during the cross-examination may be allowed by the court at its discretion. Section 8, recross examination. Upon the conclusion of the redirect examination, the adverse party may be recross examine the witness on a matter stated in his or her redirect examination, and also on such other matters as may be allowed by the court in its discretion. Next question, briefly explain what is a judicial affidavit. The judicial affidavit rule or JAR took effect on the 1st January 2013. A normal court proceeding will take around 3 to 5 or even more years to be fully decided. By the requirements of missive of written affidavits of the witness through the JAR, the time for the concluded court proceeding will be shortened. Okay, next question. An officer of a compromise in criminal case in an implied admission of guilt. What are the two exceptions? In quasi offenses or acts defined and penalized under the Article 365 of the Revised Penal Code. Example, reckless imprudence and simple imprudence of or negligence. And the second one, those allowed by the law to be compromised. Their usual examples are found in the Revised Penal Code, particularly in Article 266 of the Revised Penal Code. In order for evidence to be admissible, it may be relevant and component. When evidence is relevant and when is evidence competent? Relevance. Evidence is relevant if it has a relation to the fact in issue as the induced believes in its existence or non-existence. From this rule, we gather that there are two components of relevance. First, relevant evidence has a relation to the fact in issue. Competence, on the other hand, in addition to relevance, admissible evidence must also be competent. Under the Rule 128, Section 3, evidence is competent if it is not excluded by the law or these rules. If a piece of evidence is disqualified by the law or the rules of court, then it is not competent and will be inadmissible. What is the leading question when it is allowed? In Section 10, leading and misleading questions. A question which suggests to the witness the answers which the examining party desires is a leading question. It is not allowed except A, on cross-examination, B, on preliminary matters, C, when there is a difficulty in getting direct and intelligible answers from a witness who is ignorant, a child of tender years, is of feeble mind, or in a deaf mute, or D, of an unwilling or hostile witness, or E, of a witness who is on advanced party or an officer, direct or managing agent of a public or private or corporation or of a partnership or association which is an adverse party. Next question, what is misleading question? A misleading question is one which assumes as true or fact not yet testified to by the witness or contrary to the which he or she has previously stated. It is not allowed. When is circumstantial evidence sufficient to sustain conviction? Section 4, circumstantial evidence when sufficient. Circumstantial evidence is sufficient for the conviction if A, there are more than one circumstance, B, the facts from which the interference are derived are proven, and C, the combination of all the circumstances is such as produce a conviction beyond reasonable doubt. Distinguish burden of proof from burden of evidence. Burden of proof and burden of evidence. Burden of proof is the duty of a party to present evidence on the facts in issue necessarily to establish his or her claim in defense by the amount of evidence required by law. Burden of evidence is the duty of a party to present evidence sufficient to establish or rebut a fact in issue to establish a prima facie case. What is the standard of the proof necessarily in civil, criminal, and administrative cases? Briefly define each. In civil cases, preponderance of evidence, how determined? In civil cases, the party having the burden of proof must establish his or her case by a preponderance of evidence. In criminal cases, proof beyond reasonable doubt. In a criminal case, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. Administrative case, substantial evidence. In cases filed before administrative or quasi-judicial bodies, a fact may be deemed established if it is supported by substantial evidence or that amount of relevance evidence which a reasonable mind might accept as adequate to justify a conclusion. Substantial evidence is the last quantum of proof required by the rules. It is applicable in administrative actions which, unlike judicial actions, do not include conducting full-blown trials and are meant to be concluded of greater speed. Define what are public documents. A, the written official facts or records of the sovereign authority, official bodies and tribunals and public officers, whether of the Philippines or of the foreign country. B. Documents not acknowledged before a notary public except last wills and testaments. C. Documents that are considered public documents under the treaties and conventions which are enforced between the Philippines and the country of source. And D. Public records kept in the Philippines of private documents required by law to be entered therein, and all other writings are private. How do you prove and present in court private documents? Proof of private documents, due execution and authenticity must be proved by any of the following means. A. By anyone who saw the documents executed or written. B. By evidence of the genuineness of signature and handwriting of a maker. Or C. By other evidence showing its due execution and authenticity. The original documents rule states that when presenting a document as evidence, only the original is admissible. What are the 4 exceptions? Section 3, original document must be produced. Exceptions. A. When the original has been lost or destroyed or cannot be produced in court without bad faith or on the part of the offer. B. When the original is at custody or under the control of the party against whom the evidence is offered and the latter fails to produce it after reasonable notice. C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the facts sought to be established from them is only the general result of the whole. And D. When the original is a public record in the custody of a public officer or is recorded in a public office. Next question, who can become a witness? In Section 20, witnesses, their qualifications, all persons who can perceive and perceiving can make their known perception to others may be the witnesses. When the extrajudicial confession is sufficient to sustain a conviction. In Section 3, extrajudicial confession not sufficient ground for conviction unless corroborated by evidence of corpus delicti. So that's all. Thank you.